4 o'clock? Indeed it is. And being that it is 4 o'clock, I hereby call the Health and Human Services Committee of the Marathon County Board of Supervisors to order. The next item of business is the public comment section. Nobody has approached the bench about making a comment, but is there anybody from the public that would wish to comment at this time? Seeing none, we will move on to item 3, which is the approval of the March 2nd, 2022 and the special March 28th, 2022 Health and Human Services Committee meeting minutes. Those were sent out in advance. Are there any additions or corrections to those meeting minutes? Seeing none, do we need to take these separately, Lance? Oh, we do have a question. Go ahead, Supervisor Krause.
Yes, it says here that Anwassa Area Transit System, and then later on in the notes it says Metro Ride. So I was just wondering, there's not really a difference, so I was wondering what it was. It says Metro Ride, and then it says, on, let's see, the first pair, under educational presentations and committee discussions, number 6, A, it says Wassa Area Transit System. And so that should probably really be Wassa Metro Ride Transportation, because that's the official title. And that's what I was thinking, because I thought, oh gee, I've never seen it called Wassa Area Transit System.
Does that sound right?
This is Administrator Leonard, and Corp Counsel is here and can weigh in. The item you're reading is actually the agenda item, so I don't believe it would be appropriate to modify the agenda item as previously posted. The minutes with relative to the discussion do reference Metro Ride as you referenced.
Yeah. And Administrator Leonard, this is Corporation Counsel Pierner. I'm looking at the minutes as well. I think under 6A, Wassa Area Transit System, that is how the agenda was titled. So it would be an appropriate duplication to keep that in there. I think the discussion revolved around the use of the phrase Metro Ride, and so the minutes are consistent with the discussion at the committee level.
All right, very good. Supervisor Krause, you satisfied with that? Because we are reviewing the minutes here for approval.
Okay, so then under discussion, that is not part of the minutes. Where, that I was, number 6 doesn't say minutes there.
Are you looking at the agenda or the actual minutes?
It says Health and Human Services Committee meeting minutes Wednesday, March 2nd.
Okay.
Under 6, and then, later on, under discussion, it says Metro Ride. So I just was wondering, because I don't really hear it called Wassa Area Transit System very often, but if it is used interchangeably.
Yeah. All right, all right. Any other questions or comments? Otherwise, I would accept a motion to approve the meeting minutes. We have a motion from Supervisor Van Cray. Do I have a second? Second for Supervisor Krause. I have a second for Supervisor Krause. Any further discussion? Seeing none, all in favor say aye. 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 Opposed, same sign. That motion is carried. Thank you. Item 4, policy issues for discussion and potential committee determination. We don't have any today, nor do we have any under item 5, operational functions required by statute, ordinance, or resolution. So under item 6, educational presentations and committee discussion, 6A is recommendation from Criminal Justice Collaborating Council to not modify existing marijuana possession ordinance and a presentation from District Attorney's Office on marijuana referral and prosecution data. So this was in front of the Criminal Justice Collaborating Council a couple of weeks ago, and I did ask that the District Attorney's Office do a little presentation on similar to what was done at that meeting for the purpose of our meeting here today. So we do have Teresa from the District Attorney's Office here. It's.
Can I come up, or can I just sit right here?
Either way, from there is fine.
Okay, thank you. So thanks for having us here today. I want to point out that Ruth Heinzel, our diversion coordinator, is here as well, and she put together the wonderful data that is before the committee today. So I'm not sure how much background I should give on this. You're all aware of.
I think we're all aware of, that because we referred it from this committee to
Right.
you. It's really a matter of what you've, gathered and then
Sure.
some of the facts and data.
Sure. Obviously, everyone's aware that the county ordinance has existed for some time for possession of THC in Marathon County, and the request was to make it a $50 inclusive of cost forfeiture versus the current county ordinance that's $500 to $500 as the potential forfeiture plus court costs. So we were trying to, in assessing, it's always good to use these situations as an opportunity to evaluate what in our office, what we're currently doing. And so we were trying to determine what the problem is that they were trying to solve with this change in the ordinance. And as I understand it, it was that otherwise law-abiding citizens were being charged with possession of THC. So we looked at a couple of things. One is we wanted to make sure that everyone understands that a county ordinance that is, if someone is cited with a county ordinance, it goes on Wisconsin Circuit Court access. It's available to the public. So our office does have a diversion program. If we receive information on a referral for THC, we can look at the individual and determine if they've had any prior record and if they are appropriate for diversion. And if they are appropriate for diversion, work with law enforcement that we get that decision made before it goes on to Wisconsin Circuit Court access, and then hopefully there would not be any kind of record if they successfully complete the diversion. But just so everyone understands, if it is an ordinance, it still goes on Wisconsin Circuit Court access as an ordinance for the public to see. So we looked at who are the offenders that are being charged with a crime for possession of marijuana. What is the extent that crimes are being used for charges are being used for possession of marijuana? And also, I think of interest is the connection of possession of THC to other crimes or charges. And so we're hopeful that this information that we provide will be somewhat enlightening, I guess, for the committee. So what we're finding is that none of the referrals from the Marathon County Sheriff's Department in 2021, so we looked at 2021, we wanted it to be recent and relevant, were first-time offenders. So the idea we started with, right, was that we didn't want otherwise law-abiding citizens to be charged with crimes for civil possession of THC. And so we looked at who is being charged with possession of THC. So the other thing that helped us look at is our diversion program being used as much as possible to divert out those first-time offenders who might be referred for possession of THC. So we're finding that people that we're receiving, the sheriff's office is, I guess they would have to talk about their use of the ordinance, but none of the offenders were first-time offenders. So I guess that's where we start. And then we tried to break down the data a little bit from there. So how many of the misdemeanor THC cases were, charges were part of a larger felony case? How many were part of a case with other misdemeanor charges? So we tried to break that out for everyone to see, and hopefully, I think Ruth did a great job of trying to make this readable, this data readable. So I think the conclusion, which is, I'm not sure which page of your packet it's found on, but there's a section under a little pie graph that says 6 out of 10 misdemeanor referrals are simple possession of THC and associated with paraphernalia as the only charges in the case, but it's not a first-time offender. The data supports that the THC cases referred to the district attorney's office are not for first-time low-risk offenders and are part of a larger criminal case. The sheriff's office uses the county ordinance regularly. So nothing about this change that was proposed was going to make a difference as far as, I believe, what's already being done. But what it would do, and I think this was a great discussion that we had at CJCC, something I don't regularly look at, is where do the court costs that are associated with a forfeiture for possession of THC go? So if you're talking about making, first of all, one size fits all for everyone, essentially what that does is it takes away the discretion to treat that individual as an individual in the system. And the DA's office would be looking at the amount, if somebody pleads not guilty and we're negotiating that case, we would be looking at that individual circumstances. For someone, $50 might be, of a forfeiture might be quite a bit. For someone else, maybe we're teetering on the edge of charging it criminally, and a higher forfeiture might be a penalty that we could live with short of filing it criminally. So we like to look at the individual circumstances and determining the amount of the forfeiture. So anything that takes away discretion, I understand that there can be concern about abuse of discretion, and that's something that everybody should always be aware of and willing to discuss. But I didn't find any abuse of discretion, and I don't know that there has been anything put forth that was occurring. But if you do a $50 inclusive of costs, right now a $50 forfeiture plus costs would result in, I believe it was $200.50. Is that correct? I had it written down and now I'm not sure what I did with it. Oh, here it is. So a $50, oh, now I cut off the end of that. Do you remember, Lance, how much? I think it was $200.50. I just didn't bring it with me. But regardless, it's significantly more than the $50 forfeiture because it includes costs. So those costs are in part things that we need to pay to the state. So if those are not collected from the offender, the county then actually still has to be responsible for those costs. So then we'd actually be in the negative in these forfeiture situations. And, there is some pretty good data that supports that individuals having some accountability and some personal financial responsibility for an offense can be somewhat of a deterrent. And in this case, the personal financial responsibility would be given to the county as far as the costs go. So in the end, I think this was a great opportunity for us to evaluate how THC is being prosecuted. I know that has been a source of conversation as it related to custody situation in the Marathon County Jail. I think we've talked about that for over the past couple of years about, at some point in time, there was a thought that individuals are being held in our jail for possession of THC. And certainly we've evaluated that, and that's not the case, but it's also good to know who is actually being charged, what is the connection with other crimes. So you could have an individual, for example, who is involved in a domestic situation, and upon arrest, they have marijuana in their pocket. Or they're involved in some sort of OWI offense, and then there's THC found in the car, or a multitude of different offenses where the THC was not the reason for the contact, but it ends up being part of the total context of the case. And if that is not charged out, we find as prosecutors, that's not a battle we want to be fighting when we're leading up to trial about whether that evidence is relevant or not. And there's a lot of reasons to, as a prosecutor, you have to proceed in charging as far as your burden of proof, always knowing that you can take this case to trial if you need to. And you need to be putting this case in a position that when you're prosecuting it, if it goes to trial, that you're in the best position for an outcome that is just. So I just want to say that, you know, we do often charge it when it is associated with other charges because it's part of the total context. So if anybody has questions about the data, we have the expert here, Ruth, and if I'd be happy to answer anything or if you want additional information.
And thank you for putting that together, both Ruth and you, Teresa. I appreciate that. And I, too, was at the CJCC meeting where it was discussed, and it was a very rigorous discussion on it from the consequences on it. Bottom line was, there is a fair amount of discretion involved between the Sheriff's Department and your office as to how this is treated and going forward. There was concern about lowering the cost, that it ultimately doesn't cover the cost to the county if that would happen. And that's a concern. Obviously, we want to cover costs going forward. And I don't want to speak for Deputy Billup, but Chad did mention that really this is generally low on their radar, and it is kind of a side topic. If somebody gets arrested or stopped for something else, they may address marijuana, but clearly there's other drug issues that are much larger concern for the Sheriff's Department to deal with. So those were the main things. The one thing I didn't hear, though, there was some concern about CCAP and, you know, having those things, you know, listed out there. And did we address that at all? And
yeah, so there was some, I think, misinformation that somehow the county ordinance would prevent that. And the county ordinance has always been in place. The change that's proposed is the change in the forfeiture to be $50, I believe, inclusive of costs. But the ordinance is on CCAP. And once that is issued, if there is a plea of guilty or not guilty, it doesn't matter. It's going to go on Wisconsin Circuit Court access to be publicly available.
right.
And that's not a decision our office is making. That's just
Right.
county ordinances enforced by the county.
Okay, thank you. Supervisor Krause.
Thank you, Chair Boutke. I would just like to make a comment regarding some of this. In past discussions at the board on the use of marijuana, it was always said, you know, the opposing to legalizing it was that it was a gateway drug to cocaine and heroin and meth and other things. But yet, from this presentation, from this information, we see that it's very, very few that have marijuana and also all of the other dangerous drugs. I shouldn't say other dangerous because I believe marijuana is not any more dangerous than alcohol. But 50 years ago, I used it in college, and from my boyfriend who purchased it. And, you know, after I broke up with him, I never used it since, or any other drugs, illegal drugs. And today, if I try it, I'm allergic to it. So I'm allergic to a lot of things. But and I think it's very common that more people are using this. For me, it wasn't any different than two glasses of alcohol. So I felt it was rather safe.
All right, thank you.
I just want to be careful, I guess, about extrapolating from this data that this is a suggestion that marijuana use is down or that it reflects the reality of marijuana use in this community, because I think what it reflects is law enforcement's, and I think Chief Deputy Billup addressed this, that the focus of law enforcement is on the larger drug dealing of harder core drugs, as well as you know, overdose deaths with heroin and methamphetamine, and you know, I actually there's been a startling correlation between marijuana-related drugs and violence. And I don't know, I am not going to make any conclusions based on that. All I can say is we've observed that, we had the shooting by the glass hat. That was over THC. We had another shooting that occurred relatively recently that was over THC. So there is a connection between violence and THC that's kind of surprising. But I guess I just want people to understand that we could take a deeper dive into that if possible. We don't have a data analyst, as we've talked about as well. We do the best we can with the data, but I just don't want anybody to extrapolate from this that it's a reflection on how often THC is being used in the community. I think it's more of a reflection on law enforcement using their very valuable resources on other types of drugs as a focus.
Right.
But I would have to defer to.
And I think the scope of our inquiry on this was more about the enforcement and the actual fine. And we're not making any claim at all on the safeness or lack of safeness or whether it's a gateway drug or not a gateway drug. That's not what we're here to discuss today.
I think it's an interesting discussion, but I just don't want anybody making those types of conclusions from this data.
Right. Okay. Right. Supervisor Van Cray.
Thank you, Mr. Chair. Could you just clarify the current forfeiture amount, because it is between 5 and 500 and it is at your discretion, but is there a standard where it starts, or is every single case discretionary?
Pretty much every single case is discretionary, with the exception, and other people can correct me if I say this wrong, that I understand if you do not contest the issuance of the ordinance, it's a standard $90. Is that correct, the forfeiture? Is that what was stated?
There is a standard forfeiture, and I want to say that the citation total, it didn't have it broken out by court costs. The forfeiture plus court costs, it was a total amount.
Okay.
So when the sheriff's office issues a ticket, it comes out with a pre-populated total amount for that forfeiture ticket. And those tickets do not change. If you're the law enforcement officer and you write me a forfeiture citation for disorderly conduct, it's whatever that dollar amount is. And that currently under our system is the same as what the forfeiture ticket would be if you wrote me a citation, a forfeiture citation for possession of THC. I think, like Teresa said, one thing that it was my experience that having this conversation, like Teresa said, it's a good thing. We noticed a couple of things we wanted to also look at, and that is one of them. Should we have a system where perhaps based on the type of forfeiture, that standard forfeiture amount is separate? But like Teresa said, if you contest the forfeiture, once you write me a ticket and I say, I'm not guilty of this, and I plead not guilty in court, and I have a sit down with Teresa, she has discretion about where in that $500 to $500 range is going to be my forfeiture amount.
To offer, right? So to offer. So if they contest, if an individual contests, then there is negotiation with either with that person directly or with an attorney. And if we can reach an agreement as to the forfeiture, that our prosecutors make an offer, and if the person agrees, then that's submitted to the court, and then the court signs off on it. If there isn't an agreement, it's contested, it can go to a court trial, and the judge can make a decision on whether or not the person is going to be found guilty of it, and then from there the court would decide what to impose. But if there is an agreement reached, it's between the prosecutor and the person who's cited and or their attorney. So it is our discretion on what to offer, but ultimately it's the person's discretion to either accept that or go forward and contest.
Okay, but then the amount coming from the sheriff's department is always the same, because it just prints
they're
out
not
Okay.
changing that on the street at all. It's a standard amount, and I don't want to say for sure I know that amount, so because we don't see that they don't come to us if they plead out.
Thank you.
All right.
If I may, Mr. Chair, the only other thing that I wanted to note, I think Teresa laid out everything in the discussion very well. I think starting with what was the problem that was aimed at being addressed. Teresa laid out how we looked at it and were these really issues. One other, I think, motivating factor perhaps for the desire to have this amended was a belief that the specific language within the ordinance was somehow prohibiting law enforcement from issuing a forfeiture citation to anyone if they had a previous criminal conviction for possession of THC or even a previous forfeiture ordinance citation for possession of THC. Corporation Counsel, Sheriff's Office staff, DA's office, Teresa and myself sat down. Really, the language in that statute, in that ordinance for the county is to protect the individuals, to make sure they're not, in fact, prosecuted twice. It's not to prohibit the use of a forfeiture or limit discretion, like Teresa said. It's actually to make sure that the individual isn't both getting a ticket. You're not issuing me a law enforcement citation for a forfeiture citation for possession of THC, and then the district attorney's office also taking me to criminal court for that same underlying offense. So that was one thing we learned. I think a good thing to have a conversation. The second is this belief that, and state law says that the first time if you are prosecuted in court criminally for a misdemeanor possession of THC, that we were having this flood of felony THC cases, to Teresa's point, that are clogging up the court system and people are in jail. And what you see from the data that Teresa, Ruth, and Nikki put together, that's just not the case. There are very few cases that, in light of the discretion that Teresa's office has, the way they're using it, that's just not how those prosecutions are playing out.
So
Very few felonies are being prosecuted, and they're in connection with other things. You'll read the data that says somebody is charged with felony possession of THC, but they also have methamphetamine or heroin, or they're engaged in some violent activity. Those things are already felonies. So it's, to Teresa's point, it's prosecutorial discretion based on prosecution strategy, which is a different thing. So again, good conversations all around. Ultimately, the CJCC recommendation was this isn't a priority to modify right now, and they recommended not.
Right. It does reflect on that. It says on the top of the page that you have, I think it was the first page, THC Citation Report. County jail is up to a year, and then from there it's prison for felony offenses. And so there was some, I've heard discussion, and people have asked me about people who are in prison for possession of THC. And what if you are convicted of possession of THC and you're charged again, you can, under the prosecutor's discretion, charge that as a felony, or you could go to prison for a second offense, possession of THC, simple possession, and not dealing, but possession. And so what this report, and I thought this was good to look at too, and it's been a conversation in our office, is that those three that were referred for felony were in connection with other types of offenses. So it wasn't simply someone had possession of THC the second time and we charged them with a felony and now they ended up in prison. That's not the reality of how that charge is being referred by the sheriff's office or how it's being used in our office either. So that's also a good discussion for this committee to be informed that at least the sheriff's office is not referring those to be prosecuted that way, and we're not prosecuting that way to have those individuals end up in prison. And then it's another step to have a judge actually sentence someone to prison for that, but that's not, they're not having the opportunity even, so.
Okay. Supervisor Krause, you had your hand up a little while ago.
I just wanted to mention that Wisconsin, from the information I read, that Wisconsin ranks 14th of the states for incarceration for marijuana. Mm-hmm. That's pretty high.
Yeah, it is. Other discussion from committee members? All right, seeing none, since this was, do we need to take action on this? I don't think we do.
No, it was simply sent back for an educational item because this committee requested a recommendation from the Criminal Justice Coordinating Council on that ordinance and any potential amendment, and that was the recommendation from the CJCC was to not amend it at this time.
Okay. All right. And seeing no further discussion on that topic, we will move on. The next meeting time and location, it'll be right here at May 4th at 4 o'clock. Committee members are asked to bring ideas for future discussion. This, however, will be my last meeting. And I want to thank you all for being on this committee. It's been an interesting 2 years, to say the least, being on Health and Human Services. And I think despite everything, we did our jobs well. And I do appreciate the confidence he placed in me, and Chairman Gibbs is here as well. I appreciate the opportunity of serving not only on this committee, but on a number of committees. And I'm not going anywhere. We're still in the county. So, so with that, I would accept a motion to adjourn. All right. Supervisor Brand Crate, a second from Supervisor Krause. All in favor, say aye.
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 That motion is carried. We are adjourned. Thank you.